Due Process, winner of 24 regional Emmy Awards, including the 2014 New York Emmys for our coverage of criminal justice and current affairs. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
The mortgage bubble burst, and so did your biggest investment. Should your town be bailing you out in the name of eminent domain? It's a question that's heading toward a big court battle and the focus of this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy. Additional funding from Genova Burns and the New Jersey State Bar Foundation.
You're one of the millions owing more on your mortgage than your house is worth, and foreclosures at the door. So should your town be able to bail you out by a new creative use of eminent domain? Not seizing houses, but mortgages, restructuring them to make payment easier to manage. An idea that's taken hold in one Essex County town where more than 1,500 houses have been foreclosed in the years since the housing bubble burst. I'm Raymond Brown.
And I'm Sandra King. The town is Irvington. The idea, described by some as radical, has already been sanctioned by the town council, and though designed to keep families in their homes, save at-risk neighborhoods, staunch decline, proponents are braced for a fight. Proponents like Wayne Smith, the mayor of Irvington, and Chen, dean of Rutgers Law School, the state's former public advocate and an executive producer of Due Process.
And on the other side, Timothy Duggan, a bankruptcy and creditor rights lawyer with an expertise in eminent domain. Welcome to all of you. Tim, I'm anxious to get to you, but I'm more anxious to start with you because the question is, Wayne, what made you think that this was an important strategic response to the challenges facing Irvington?
Well, first of all, we had some advocates who came to the table to have a conversation with us, and the conversation was robust, and we looked at some of the things confronting us, and we said, okay, this could be a tool that we can use that will help some people. We didn't see it as a panacea, but we said, you know, we've got to do something aggressively to help people in foreclosure. There are various ways, and we have some other tools that we're using, but we've identified at least 199 homes.
Now, as of last night, you said.
Yeah, absolutely.
You have 199. What's the total population of Irvington?
Oh, we're about, the census says we're 53,000, we're really about 70,000.
So before we go on, the question is, why would you think that a tool that could assist 199 would be significant in attacking the broad range of problems that Irvington faces?
Well, first of all, when you talk about arresting blight, so we know from the homes that have been foreclosed, the devastation that is caused in neighborhoods. So if we can help people stay in their homes, that stop those homes from being destroyed and vandalized, et cetera, from being vacant, it's an effective tool to help our stable neighborhoods stay stable.
So, Tim, this sounds like a nice thing for the people of Irvington. You don't like it?
Well, no, I like what they're trying to do, and I think a lot of the cities are trying to make that, add tools to the toolbox, and I think that's a great idea. My concern is when you're exercising a constitutional power and using a taking clause, let alone the legal challenges you have, you're only, one, I don't know if it's going to help. Taking 199 homes is going to do anything in the city. I think if the cities come forward and work with the banks and try to do it voluntarily, that's different. So
but let's get to what's probably the underlying objection that you have, which is somebody has to lose in this, right?
Yes, I think what happens
is the people you represent.
Yes, my clients potentially could lose, especially if you're taking current mortgages. And I don't know what the status of the mortgages on the 199 homes. But when you look at the Richmond program, the vast majority of the mortgages
Let's stop
were
you
current.
There. Richmond, California, the
Yes.
first town to try to do this still not off the ground there.
Yes, they're proceeding. My understanding is they're proceeding forward. There was a legal challenge in federal court. The court said your challenge is too early. We call it ripeness in the law, and that's up on appeal. But one of the problems there were over half the mortgages were current. These are people that are paying. This program was not limited to just mortgages that were in foreclosure or people on the eve of foreclosure where it's a foregone conclusion. So that's one of my major problems is you're picking out current mortgages. The second is...
So you'd be more satisfied with it if, in fact, these were people who were not current and who were about to lose their homes?
Yeah, I think that would make it less burdensome and less problematic. Because I also believe from a taxpayer point of view, you're going to have to come in and value these mortgages. When the government takes your property, they have to pay fair market value for that property, for the instrument they're taking, the mortgage, not the property. Under the theory of the condemning authorities, which would be the government, the value of that mortgage is a percentage of what the home is worth versus what is this mortgage worth. And I think that's going to be a major fight for the court to determine what's the proper valuation standard when you come in and value the mortgage.
So you're wearing a bunch of hats today. You're a formal part of the due process family. You've been traditionally in the public sphere, though not attached to a particular town. And you're an intellectual and a scholar. So you have to bear all those burdens for us. If, as the conversation between Sandy and Tim evolved, it's clear that part of the problem is that with properties undervalued, the question is, or underwater, who's going to bear that difference? Is it the mortgage payer or the bank or the mortgage company? But all this has constitutional implications. So why don't we start there? What does the Constitution have to do with eminent domain and this question?
Well, you're right, Ray. When I was the public advocate, I was well known for taking stances, legal positions, successful in many cases, I might add, to prevent eminent domain abuse. And I haven't changed those views. And eminent domain, in order to arrest right, has to be carefully monitored to make sure it is not abused.
But you like this use?
That being said, in this case, I think once it is established that what we were truly doing is trying to arrest blight, that is a proper purpose for eminent domain in this state. I've never contested that. And with that condition, I think the use of eminent domain in this area, if it has the salutary effect of preventing the homes which are subject to underwater mortgages from them sliding into foreclosure and thereby very likely abandoned and becoming worthless, that benefit is obviously one which town officials like Mayor Smith would be eager and justifiably so eager to
But isn't another prong of the
remedy.
constitutional inquiry that the Supreme Court has talked about is what's the value being received? And here we have, in a sense, a contest between two different groups of citizens. You have individual citizens who are underwater not through any fault of their own, but because the market collapsed. And you also have companies which, in some instances, may have been totally innocent of dealing with derivatives or anything that caused the market collapse. How does a town get involved in deciding how to allocate that loss?
Well, I think Mr. Duggan is right to this extent. The issue that will probably decide this is how to engage in the process of valuation. If a town takes the mortgage, as opposed to the bricks and mortar itself, but the mortgage, how do you value what it is fair, what is just compensation for taking that mortgage? Because the Constitution clearly requires just compensation for that taking. I think...
Does that imply that Wayne has already consulted with experts to try to figure out how that process is going to work?
If we look at the Richmond dynamic, there are financial institutions that have modeled at how they can make a profit from engaging in financing these underwater mortgages.
Yeah, we should make clear, it's not the town of Irvington that's going to go into its treasury and buy these mortgages.
That's why I introduced that concept. We will do an RFP to engage a financial institution and people have figured out a way they can make this profitable. One of the trade associations, SIFMA, has said to me, well, the company that's doing this, they're going to make money. I said, well, isn't that the American way? You solve a problem and you make money.
But somebody's going to lose too, right?
I don't know about anybody losing, but at the end of the day, the public good that's served is that we save neighborhoods and we keep people who would be out on the streets in their homes.
Do you seriously doubt, and I don't mean that in a sarcastic way, but do you seriously doubt that there's likely to be litigation if you undertake this program? Because some people perceive themselves as being losers.
Listen, Sandy King described it that we're prepared for the fight, and we're prepared we think it's worth the fight. But more than the fight, I think the debate becomes important because we have to come up with a viable solution as a society when we have communities devastated.
But this leads to another question, and we have lots of questions. I mean, nobody at this table had anything to do with the collapse. This is a problem
Well,
of
it depends.
national, and to some.
I don't know what you invested in.
Well, I can assure you that I wasn't dealing with mortgage-backed derivatives. So what I'm saying is that it's clear that this is a problem to some extent of national and international economic significance.
Yeah.
It's not wrong for the town of Irvington to take the lead, or the little town of Richmond, where I once lived in California. But at the end of the day, you're taking on problems that have huge dimensions well beyond the town of Irvington.
Well,
and that's also a sign of leadership, but it's also a sign of boldness and of possibly getting into a circumstance where this could grow beyond the capacity of Irvington to handle the fight.
Well, we're certainly going to be Irvington focused about these at least 199 individuals that we want to help. So we clearly
you
have,
reject the mantle of bold leadership?
No, I do. No, I take this. and I also take the challenge of if we become an example like Richmond has and how we got engaged, that maybe other communities and other sectors of the society will begin to help address
And you're
this
going to
problem.
have help. You've already got the ACLU
Absolutely, our
on your
partners, New
side.
Jersey's
We should
Communities
mention that,
United.
that Ron is on the
I'm
board
sure,
of
yeah.
both the New Jersey and the National ACLU. The ACLU is with you. We assume that there is going to be a whole lot of gathering, looking at Irvington and entering this fight on the in the courts, on the legal arguments. What about from your side? What do you see? You got the ACLU and other community public interest
law
organizations who are going to be fighting with the arguments that Wayne has just told us. What's going to be coming from your side?
The
And how
argument on
strong
the
is
other
the
side
fight going to be?
I think the fight's going to be very strong because they're not sure how far-reaching it is, and I don't think
And well-funded and...
it's going to be. I do believe that just looking at the fight out in California, it's a very good substantial firm. I do think on both sides it's going to be an even ballot. I think both sides are going to be funded, and I do think that it's very similar to the Kelo case that went to the Supreme Court. It's that type of argument. Can you prove the benefit that you say to meet the public purpose? Is there enough of a public benefit? There's all sorts of legal challenges. If the property's located in New Jersey, but the creditor is located in California, does Jersey even have jurisdiction? Where is the property that's being taken?
Even if we can identify the creditor,
you
that's
can-
a whole nother.
And that's one of the problems that we see is, as these instruments were being transferred, that slowed up the foreclosure process in New Jersey. You have mortgages that have been in default 3 or 4 years that the foreclosures are just getting started. That means that a lot of the problems that Irvington is going to see are going to continue for a couple of years, where maybe Florida, who's further along in the process, because their foreclosures moved quicker, they're going to see an earlier end to their problem. Here in New Jersey, we have a backlog of cases that are very old that are just starting to come forward.
Tim just referred to Kelo. And Kelo is a case about a decade old, but it was a case that was hugely followed about eminent domain. And while there are lots of it was a 5-4 decision with some concurrence, a complicated decision to interpret. But it certainly seemed to signal an increased interest on the part of the federal judiciary in looking in more detail at eminent domain questions. Would that make you more or does it make it more likely that we might see a challenge that might be entertained ultimately in the federal courts?
Although, of course, the controversial thing about Kelo is the eventual result is that you can use eminent domain for general economic benefit, even if the area was not blighted. And that's what caused a very negative public reaction to it. Now, here in New Jersey, we have additional state constitutional constraints, and that's what we were fighting before. But even with those additional constraints, that was really on the issue of whether the area had to be blighted or not in order to use eminent domain for redevelopment. And I think in this area, we're hopefully beyond that issue. These are properties that, well, I would say, in order to consider this, they should be
Let me see if I'm
should be
are you
blighted.
saying that it's your view that probably the legal issues that are going to come out of this admittedly new tool are probably issues that have been resolved both by the state and U.S. Supreme Court, or are there open areas?
I think, unless Kelo is reversed, I think at a federal level, at least on the issue of the constitutionality of use of eminent domain, I think the answer is yes. The court has answered that question. The issues, there may be state law issues on whether it's proper use under state law.
Well, do
of
the
eminent
courts
domain,
care about the question of the scope of the taking? If this winds up being an allocation of loss question, would the courts of the state or the federal courts have an interest in looking at either the process by which that was achieved or the actual results?
Well, I'm sorry, the unusual thing about this that attracts people's attention is that you're not exercising eminent domain on real property itself,
Right.
but on one aspect of it, the mortgage, the intangible attachment to it, which makes it sound unusual. I don't think legally that that's particularly controversial. Eminent domain is not limited to bricks and mortar. It can be used on intangible property,
What about the
although
other
it usually
issue?
isn't.
Because Wayne seemed anxious to jump in on the allocation of loss issue. Because at the end of the day,
listen,
in addition to principle, what's
some
going
of
to
these
motivate
securities
people.
insured? Have the mortgages actually been paid? Who owns them? These are all underpinning questions that determine if anybody had a loss. And so the broader question that we find with all of these kinds of mortgage-backed securities and the financial mechanisms that cause people to get in trouble in the first place, it's been insurance on some cases. Maybe the mortgage has actually been paid.
So you're saying that with this bold leadership, there will be no loss to be allocated?
Well, it could potentially be. It depends on the particular case, and this process is a very complicated process. The issues of law and who made money behind it, and were the mortgage actually satisfied. These, as you peer
Tim,
back,
can you contemplate that? Let's say of the 200 mortgages that look like they're going to be at issue in Irvington, that the vast majority, there might not be a loss suffered by any entity during this process?
Well, first of all, I don't think any of these mortgages have been paid off. I mean, it's a rarity where a mortgage was paid off and you can't prove it. If you're paying off your mortgage, you can do it. There could be issues over who owns it. There's been a lot of litigation over who physically has that original note. And if you don't have that original note, you cannot come to court and foreclose. And I think that's an issue that you could ultimately get down to. But there will be a loss, and I do not think the courts are going to care about it because it happens in all eminent domain. If I'm going to come and take your investment property and I offer you fair market value, I can guarantee you that you will not agree with the government's number.
So
you
fair
might
market value as a term of art is not fair market value that an ordinary person might think of.
Well, no, I think
in
what
this
happens is in a normal condemnation case, I've had cases where the property owner's appraiser, credible, very good appraiser, is 2 or 3 times the value of the government's appraiser, who also is very good and very credible. So you're going to go to a jury trial on experts that could be 3 or 4 times apart, both qualified, well-funding, and a jury's going to pick a number.
And what happens
Whoever
then?
wins is going to say they lost. The other side's going to say they lost.
How do you take
Well,
that
I
appraisal?
think the issue here on valuation is this. Of course, a mortgage is going to have a face value to it on the remaining debt. So is the fair just compensation just to pay that? If that were the case, then, well, for one, there would be no incentive in doing this, but probably the mortgage holder might not care. But the reality is that a mortgage that is attached to an underwater mortgage in a property like this, which is, let's face it, probably heading towards foreclosure, in which the property itself would become much even less value, potentially worthless. In the reality, in the marketplace, what is the fair value of that mortgage? If people do rationally what they do rationally in the marketplace, if there were an efficient decision-making mechanism, what people might do, they sit down and negotiate, and they would write down the mortgage such that the mortgage holder gets some return on their investment, but in a way that the mortgagor can actually realistically pay it off. This process, in a way, is designed to substitute with the fact that that process is not going on. It's not going on because these mortgages very often are held in pools where you have an aggregate number of decision makers who cannot, through any collective action, engage in that negotiation process on their own. So this is basically forcing it to happen.
I'm glad you used the word aggregate because it makes me come back to a policy question that I'm assuming you've thought through. There are long-term implications for Irvington and for other cities that embrace this. Do you see, or did you worry about whether engaging in this kind of a program might, in the long term, cause either retaliation or people to be or bankers and others to be uninterested in investing?
We're prepared for that. We've just sent a letter along with 25 other elected officials from around the country to Attorney General Holder, asking him to intervene as cities like mine who had a historic pattern of redlining without any of this.
But might this make the lines brighter?
And that's what we're saying. We have to intervene early. If this is an approach the courts will decide some of this, and we think it's an approach that's effective to help resolve some of the issues in our community, that he should let it move forward and not let people, banks, and some have done this in Richmond, threatened Richmond, that they were going to redline that community. So here we are, Civil Rights 101 again, and we're prepared for that fight because we have a lot at stake here.
So when you've got 199 people whom you think are qualified, give me the profile. What makes them qualified?
Well, their properties are based on the PLS mortgages, private label security mortgages. So that's the first criteria. Number
Do
one,
they have to be current?
well, we haven't got to that point yet, but one of the things is this will not help everybody in that whole mortgage problem situation. But
Who won't benefit from this?
well, let me just say this. They have to be working. There has to be some income, so in order for them to get a principal reduction. So there's some criteria that's being developed for each person that will fit a certain profile, and whether or not they're current or delinquent has not been established yet. He makes the argument that if they're paying their mortgage, that they don't need help, and that might be an argument that some people will make. But we've got enough people out of that 199 that are in the early stages of foreclosure and could possibly be helped. Now, his solution is voluntary compliance. We'd love to do that. We wouldn't be at this game if it would work, if the banks would come forward. The debacle around how the financial community has handled people trying to even get mortgage modifications is horrendous. Sending documents, and even attorneys who are representing people, sending documents 4 and 5 times. I've met with tons of the financial community saying, you've got to do a better process than that. If people, we wouldn't even be at this day if you were doing credible mortgage modifications and so forth. And I've also challenged the financial community. If you don't like our answer, give us one that works. Give us one that works. What is your solution to a national problem? And Congress and everybody else needs to step up to the plate. One of the things that I've talked about is there's got to be some resolution trust kind of solution around the foreclosure crisis in this country, because it affects a lot of communities. And unless we do something like we did with the savings and loan, we're going to have trouble all over.
So Ron, how long do you see this process taking? There are 199 people lined up. They think that they're going to get some help right away. What's your guess about how long it takes for this to get into the court and then through the courts? And are those people going to be long gone?
You know, that's a tough question, Sandy. Like any trailblazing process, it's going to take some time. I think we're all three of us are.
And we've told people that as well.
Agreed. This is going to go through the courts. There is no doubt about it, because there are a number of novel legal issues that have got to get resolved if this does set a precedent. So I personally commend Mayor Smith and Irvington for wanting to fight this fight. It may be a while. This could be a long haul.
It also means, doesn't it, that little Irvington is going to get a whole lot of national attention.
Oh yeah, and listen, and it should, because we need help, we need resources, we need things that move this process forward. We're an emerging economy, and foreclosure is dragging some of that process down. And so at the end of the day, we didn't intentionally try to become a national issue. We wanted to help some families in Irvington stay in their homes.
But Tim, you see this as something that, if Irvington were to win, spreads all over the country and goes against the interests of your clients?
It can. Plucking current mortgages out of these pools could be problematic if it's done on a wide scale. If you're doing 199 homes, the reality of it is I don't think that's really going to harm anybody if it's limited. But if you took all the large cities and Wall Street thought they could make money and they started lining up with large pools of money and you came in, you got to follow who's making the money. Is this really going to work? And I think at that point it could be problematic, because they are focusing on loans that are current. And that raises a huge issue on valuation. If I have somebody paying, what is that mortgage worth versus a mortgage that's 2 weeks before a sheriff's sale? And I think that valuation standard is different.
Tim, it's unfair to ask you to speak for a whole industry, a little outside of your mandate.
And with only 30 seconds left.
Okay, but the other question is, one of the things that Wayne implied was that he hasn't had the kind of creative engagement with the financial community to try to work this out. Do you see that coming from anywhere around the country, or are we going to be here a year from now talking about the nuts and bolts of this program? And you got to say yes or no.
I think we'll be here in a year talking about the nuts and bolts. I do think the only solution the banks have come up with are short sale programs and modifications. The problem is you generally don't get the principal reduction.
And the other problem is we have to leave it there. But our thanks to Mayor Smith, Dean Chen, and Tim Duggan. And our thanks to you for watching Due Process, for thinking along with us about tough questions of law and justice.
So we hope you'll join us again next week and every week, that you'll stop by our website, dueprocesstv.rutgers.edu, where you can watch our programs on demand or join us on Facebook. Give us your ideas. For Sandy, Associate Producer Tanya Ivanova, and all of us here at Due Process, I'm Raymond Brown. See you next time.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.